So I hope my screen is already visible to you. Very good morning, all the participants. Today, let us have an overview of the various business laws. The coverage is 4 marks, but besides this 4 marks, generally they are framing the case study based on the business laws only. So practically, you can presume that it is of 12 marks. And in Companies Act, their main focus is on winding up provisions, Section 8 companies, and amalgamation and reconstruction. So these are the 2-3 areas we must focus. So we'll have just an overview today so that we can move accordingly. And we'll have next session on case studies, maybe on Saturday or Sunday, depending upon the convenience of all. So regarding prospectus, in prospectus also, they are asking about red herring prospectus. So what is red herring prospectus? In some of the TV ads, we must have heard about this concept, red herring prospectus. So this red herring prospectus, what is this red herring prospectus? Anyone? KV Kumar ji, can you tell me क्या होता है red herring?
Oh, red herring prospectus to be submitted before 3 days of issue of public issue.
Okay. And whether this red herring prospectus and final prospectus are same or there could be difference?
Oh, brief रहेंगे sir red herring में.
Right. So if there is any variation between the red herring prospectus and final prospectus, that also needs to be highlighted. And then you have to file the final prospectus with the ROC and SEBI regarding details of capital raised, quantum, closing price, etc. So on red herring prospectus, they might ask you a question. Prospectus, as you know, whether private companies can issue prospectus, the answer is no. Basically, this is required for initial public offerings or offer for sale. What is offer for sale? And what is the difference between IPO and offer for sale? These are very basic questions. I think Sudhir Gupta ji will be able to answer. So Sudhir ji, what is the difference between IPO and offer for sale? I think in offer for sale, the existing shareholders, they are offering their shares. Like promoters are offloading their stake. And in IPO, public is being invited. So this is the basic difference between IPO and offer for sale. So offer for sale is by certain members, existing members, further issue of shares to public. So before issue, you have to file the prospectus with ROC along with all attachments. The validity of the prospectus is for 90 days. So it's not that you can issue a prospectus and you don't go for IPO. So validity period is also for 90 days. And public offer securities to be issued in demat form only, because nowadays it is to be issued in demat form only. About red herring prospectus, we have already seen. It has to be filed with ROC at least 3 days before the public issue. Okay. And any variation between
sir, excuse me sir, private
yes.
company prospectus file करने की जरूरत नहीं.
हाँ.
Private companies.
Because private companies actually they cannot offer shares to public. They can go for private placement.
Okay, sir. Okay.
So that is the basic difference, because it is prohibited for private companies to invite public. And even suppose they are doing private placement, that private placement offer also cannot be renounced in favor of somebody else, because that will mean indirect way of offering it to public. So it is directed only for the persons to whom it is offered in case of private companies. So red herring prospectus, you have to file it with the ROC at least 3 days before the public issue. And if there is any variation between the red herring prospectus and final prospectus, then it needs to be highlighted. So final prospectus to be filed with ROC and SEBI regarding giving the details of capital raised, quantum, closing price, etc. So there is a concept of shelf prospectus also. So what is this shelf prospectus? Like in case of these IPAs or information utilities, we have heard the concept of in principle approval. So this is something similar. So this shelf prospectus, it is valid for a period of 1 year from the first offer. Because if you want to offer the securities in tranches, because you need the funds at different stages. So in this case, you will be able to issue the shelf prospectus. So shelf prospectus validity is 1 year from the date of first offer, and it will cover the subsequent issues.
सब्सिक्वेंट इश्यू ऑफ एसपी क्या है सर? एसपी प्लस आईएम.
भाई ऐसा है, ये शेल्फ प्रोस्पेक्टस है और वो है इंफॉर्मेशन मेमोरेंडम. सपोज देर इज एनी वेरिएशन, तो देन देर इज ए कॉन्सेप्ट ऑफ इंफॉर्मेशन मेमोरेंडम. नाउ प्राइवेट प्लेसमेंट. प्राइवेट प्लेसमेंट में क्या है? दिस ऑफर इज टू बी मेड टू ए ग्रुप ऑफ पर्संस. ठीक है, मैक्सिमम इज 50, but it excludes qualified institutional buyers and employees. Qualified institutional buyers, you know already, we have read this concept in IBC also. Basically, qualified institutional buyers, this concept is there in SURFACE also. So qualified institutional buyers are basically, say, banking companies, asset management companies, asset reconstruction companies, mutual funds, etc., foreign institutional investors, etc., etc. And employees are also excluded from this limit of 50 persons. Now, suppose you have already placed and this offer cannot be renounced. So, no right of renunciation is allowed in case of private placement. Why? Because it will amount to indirect offer to the public. So, if first private placement is pending, then second private placement is not allowed unless first is closed. Number of applicants increased, then part 1 applies. Okay? No right of renunciation is allowed. Money will be allowed to use only after allotment, and allotment should be done within 60 days, or you have to refund the money in next 15 days. If you fail to return the money, then you have to pay interest at the rate of 12%. You cannot advertise for this private placement. You cannot publicize any document for this. And in this case of private placement also, you are required to file form with the ROC within 15 days of the allotment. Naturally, once you go through this PPT, you will have questions in your mind. So you can pose those questions in the group so that you are motivated to study further. Deliberately, this is very basic. Now, share capital. Share capital, as you know, is two types: equity share capital and preference share capital. In case of equity share capital, you could have the share capital with the same voting rights, or there could be concept of variation of voting rights also. In case of preference share capital, they are not allowed to be a part to every type of meeting. So preference shareholders, they are allowed to attend meetings only which either affect their interest as a preference shareholder, or in case dividend is not paid for a certain period, or in case it is the application for winding up or liquidation. So that means in case of emergency only, they are allowed to attend the meetings. So preference shares, they are always redeemable or compulsorily convertible. Maximum period is 20 years or 30 years in case of infrastructure projects, and preferential rights during winding up and liquidation, they differ as against the normal rights. So they can attend the meetings only if their rights are being affected, or it is a case for winding up or liquidation, or dividend is not paid for 2 years or more, then they are entitled for voting in all the matters which affect the company. Now, regarding if you want to issue the share capital with differential voting rights, then 3/4 consent or special resolution is to be passed. Then you have to take the approval of those persons whose rights are affected. Then 3/4 consent of that class is also required. Now, suppose some people, they do not agree to this issue of shares with the differential voting rights. Then there is a minimum threshold. So if 10% or more agree, if they disagree with this differential voting rights, so they can apply to the tribunal within 21 days, and such variation is not permitted till order is passed by the adjudicating authority or NCLT. And this order has to be filed with the ROC within 30 days, and then the order, whatever is done by the tribunal, it is binding on order. Registration of charges. So whenever you offer your property as security, so interest, this, it has to be registered. As you already know, there are three types of registration authorities. One is information utility, which is there in case of IBC. Then there is SARSAI. SARSAI is there in case of SARFACI, and here it is MCA. So these are the three authorities with which you have to register your charge. Even satisfaction of charge also has to be registered. Now, what is the procedure? What if a person does not go in for registration of charge, whether the other party can do so, or whether the registrar can do on its own? All these things, they are discussed in this concept of registration of charges. I think I have already given you the detailed playlist of various video lectures. So it contains, I think, more than 20 video lectures. Some of them may be repetitive, but still you will get a detailed lecture, video lecture on each and every topic. I think I have already shared that in the group, that playlist. KB Kumarji, I think I have shared.
Yes, sir.
Yes.
Yes.
So this form has to be filed within 30 days of the creation of the charge. So whenever you create a charge, you are required to file a form with the ROC, MCA. Then if you fail to register your charge, then another 30 days is allowed with additional on after payment of additional fees. And after such period, application is to be filed with ROC, which permits another 60 days with ad valorem fees. So ROC thereafter issues certificate of charge in CHG1, CHG2 and CHG3. In CHG1, you have to apply for this creation of charge. So if charge is not created, then liquidator can still consider the claim. Suppose a company goes in for liquidation and a secured creditor says that, okay, I was offered security. This is the agreement. This is the loan agreement, or these are the terms of engagement which were entered into by CD with me, but this charge is not created. Then based on certain documents, liquidator can still consider the same. Now, what happens if the company fails to create the charge? If the company fails to create the charge, then the person in whose favor charge is created, he can also file with the ROC in the manner what is prescribed along with the fees. And ROC will issue notice for the same. And if no reply is received from the company which created the charge, then ROC will register the charge. In this case, the person who has applied, he will pay the fees. And satisfaction of charge similarly also has to be registered within a period of 30 days and then another 30 days with additional fees. And ROC will issue notice for confirmation if within 14 days, if form signed by both, then no notice. Now, annual return and accounts. So these are some of the provisions regarding annual return and accounts, very brief. So today we will be discussing it in very brief. You can note down your queries. You can go through my video lectures, and then we will have a detailed discussion along with case studies on some of the topics which are frequently being asked in the examination. Now regarding this annual return and accounts. Annual return is required to be filed within 60 days of the AGM. And if no AGM is held, then you have to file the annual return with statements specifying reasons for not holding AGM. Within 60 days of AGM would have been held. Okay. If listed company, if you are a listed company or you are a company having paid up capital of 10 crore or turnover of 50 crores, then annual return is to be certified by a practicing company secretary. Okay. And this extract of annual return shall form part of the director's report. So regarding annual return. Now regarding accounts. Accounts are required to be filed with ROC within 30 days of the period within when the AGM is being held. And there could be a situation where the accounts are not adopted. So in case accounts are not adopted by the shareholders, then in 30 days of the adjourned AGM, you have to file the accounts with additional fees. And if no AGM is held, then you have to file the accounts with statement specifying reasons for not holding AGM, because sometimes there may be deadlock in management. So in such cases, AGM may not be held. So you have to specify the reasons for not holding AGM, and you have to give those reasons within 30 days of the period when the AGM would have been held. Okay. In case of consolidated accounts and foreign subsidiary accounts, you have to enclose the details accordingly. Annual general meeting. So every year you have to hold an annual general meeting. First annual general meeting is to be held within 9 months of the end of the financial year. And in case of subsequent and AGMs, it has to be held within a period of 6 months. There cannot be a gap of more than 15 months between two AGMs. If you want an extension, that can be granted if the reason is valid. Maximum is 3 months. Timing of holding AGM 9 a.m. to 6 p.m. other than on national holiday. Preferably, it should be held within the same city, village, or town. If you are an unlisted company, then you can hold it anywhere with the prior approval of all shareholders in electronic mode. If you fail to hold an annual general meeting, then members can make an application to the tribunal and tribunal will give the directions to hold, and one person, one member in person or proxy can constitute meeting in such a case. Regarding extraordinary general meeting. So company can convene at any time for special reasons as it deems fit. Suppose the company does not hold this meeting and there is a pressing issue, then members holding 1/10 of the paid up share capital, they can request to board of directors along with reason for calling extraordinary general meeting, duly signed and send it to the registered office. Now suppose board, despite this members notice, does not act. So if the board does not act within 21 days and maximum 45 days to convene the extraordinary general meeting, so then the requisitionist, the person who made a request, he can convene it within 3 months of the requisition date. And whatever are the expenses for holding this extraordinary general meeting, they will be reimbursed from the company. And if the quorum is not present in the meeting, then the meeting shall stand cancelled. Now quorum. There is a question on quorum also. Sometimes they ask the question on quorum. So quorum of the general body meeting in case of public limited company, if the members of the company is less than 1000, it is 5 members present. If members of the company is between 1000 to 5000, then 15 members present. And if the members of the company is more than 5000, then 30 members present. So KB Kumarji, what is the difference between a shareholder and a member? Is there any difference or both are same?
Members are registered with registered shareholders, sir.
Actually, members are those persons whose name is entered in the register of members. So there is a register of members. If your name is registered, if your name is entered in the register of members, then you are a member. Otherwise, you are a shareholder. Suppose you buy the shares from the public and you have given it for transfer. So then you are a shareholder, but you are not a member. And there is a provision for closing of the members register also. Normally before declaration of dividend, because some cutoff date has to be there. So private limited company, 2 members present. So you can research on your own, because this PPT, this presentation will give rise to many questions in your mind. So you can study those questions on your own from Companies Act
Okay,
also. Sir. If you are not having a latest copy of the Companies Act, you can go to my website and there Companies Act is available along with rules. Everything is there. So let me show you that also. I think you are already aware about it, but let me share my screen also, okay, where you can get a copy. Because sometimes what happens is you are not having a copy of the Companies Act also. I think you are already aware about my website, carkgupta.com. So you can go to this website. So this is my website. I hope it is available. So now you go to Knowledge Bank. In Knowledge Bank, you go to Acts. And in Acts, you go to Corporate Laws for Companies Act. There are many acts available. So Companies Act is there, Companies Act 2013. Then you have to go chapter wise. So whatever chapter, because all the chapters are not in our syllabus. So you can mark the chapters which are in your syllabus and you have to study only those chapters, not the entire Companies Act. Okay. And here you will find all the chapters along with the rules and regulations. Suppose it is on this prospectus and allotment of securities, then it will give you section wise. And wherever the word prescribed, etc. is written, you have to click on that part and the relevant rule will also open accordingly. Just a minute. Okay, so we have covered this. So if quorum is not present in half an hour, then the meeting shall stand adjourned, maybe next week on the same day and same time, or at any other date or time as may be mutually decided. And if the adjourned meeting also quorum is not present in half an hour, then the members present will constitute the quorum. ठीक है? ये almost similar से provision. Regarding CSR, sometimes they ask questions on CSR also. So first is applicability of CSR. So company having net worth of 500 crores or turnover of 1000 crores or net profit of 5 crores. So such companies, they will constitute CSR committee and they will make CSR policy. And listed company with 3 or more directors and one of them must be independent directors. They will be members of the CSR committee. And in case of unlisted company with 2 or more directors, they are required to form such CSR committee. And you have to spend 2% of the average net profit of immediately 3 preceding financial years in case of. So this is basic, but detailed recording is available. Detailed video lecture is available on this CSR, how this profit computation is done and how this amount is to be spent. If this amount is not spent, then what will happen? So all these things are available in corporate. So, but they will not ask so much details. But I think I have
For
explained
exam
everything.
purpose, this is okay, sir.
Yes.
For exam purpose, this is sufficient.
Yes. Now registered valuer. Because at least this much you must remember. If they ask
Uh,
you question out of this, then you must be able to answer. This is at least expected of you. Now regarding a registered valuer. So valuation is required for property because sometimes students are also confused that the syllabus is so detailed, so vast. So how much to study? So this is very basic and we must remember at least this part. Or whatever questions crop up in our mind after reading this. If you want a detailed study, then I have already shared with the playlist with you. So you can listen to that. Valuation is required for property, shares, securities, stock, debentures, goodwill, net worth. So whether it is tangible, intangible, for everything, valuation is required. So there are stipulations regarding qualifications, experience of registered valuers. Appointment has to be done by the audit committee, and in absence of any audit committee, then the board of directors will appoint the registered valuer. So valuer shall do impartial, true and fair valuation. The valuer shall exercise due diligence while performing his function, and valuation should be as per the rules prescribed. The valuer should not have any direct or indirect interest in the company for which he is doing the valuation. And the period is 3 years prior to the appointment or 3 years after the completion of assignment. If there is any contravention, then the penalty can be levied on the registered valuer. Penalty amount is 25,000 rupees to 1 lakh rupees. And if the valuer does anything intentionally with a intention to defraud the company or members, then there is a provision for imprisonment of 1 year and fine of 1 lakh to 5 lakh. And in case there is a conviction, then the valuer, whatever fees he received, he is required to refund that remuneration also and is required to pay damages to those who suffered the loss because of such inappropriate valuation. Now regarding this compromise arrangement or amalgamation. So one of the most frequent, most favored topics of the examiner, compromise arrangement or amalgamation. So I'll share the detailed presentation also on this. And there is a particular case study also, which we did with practicing company secretary Mundraji. So that video lecture also I'll share. I think I have already shared it, but that PPT also I'll share. So compromise can be done with the creditors. Basically, compromise means what? Compromise means agreeing to accept something less than what is due. So compromise can be done with creditors to forego some part of the amount due, or debenture holders, they forego their unpaid interest. So what is the meaning of arrangement? Arrangement means the percentage of debt which is converted into equity shares of the company. And then amalgamation includes merger or demerger. There is a scheme of corporate debt restructuring also, and a scheme of restructuring of debt is as per RBI guidelines. It is outside the purview of court or legal proceeding, and then it should be beneficial for revival of the company and safety of the bank. Now regarding this compromise arrangement or amalgamation, let me take you through Companies Act. Let us study some of these aspects in detail. Just a minute. Just give me 1 minute. Just allow me 1 minute. Okay, yes. So this PPT also I will share with you. I hope it is visible on your screen. Compromise arrangements and amalgamation. So what was the background? So actually, this compromise arrangement or we'll just devote 10 minutes on this. So compromise arrangement and amalgamation, it was going on as per the provisions of the Companies Act 1956 till 14th of December 2016. Then on 7th November, central government issued a notification for enforcement of sections 230 to 233. So then, because it came sometime after this IBC, so that is why it is important. You can go through this. This is the one-page summary. One-page summary on section 230 to section 240. For the benefit of students, I have prepared this one-page summary. So basically what happens in case of compromise arrangement or amalgamation? So an application is moved before NCLT that okay, the members or the creditors, they are agreeable to accept something less than what is due to them. So section 230 says that NCLT will order the meeting on application by the company, creditors, members or liquidator. So the application for this CAA can be moved by the company, by the creditors, by members or liquidator. If there is any objection, so then who can object to such meeting? Who can object to such compromise? Those constituting not less than 10% of the shareholding or 5% of the outstanding debt. And there is no meeting if this is confirmed by 90% of the secured creditors. 231. Section 231 says NCLT has the powers to supervise or give directions for conducting the meeting. 232 talks of merger and amalgamation. So if there is any fees for authorized capital, suppose two companies are merging, okay? And one company has already paid the fees. So fees for authorized capital is adjustable. Then there is a concept of absorption, formation or division also. 233 talks of merger of small companies or wholly owned subsidiary companies. 234 talks of merger with foreign company as per RBI guidelines. 235 talks power to acquire shares of dissenting shareholders from the scheme in case 9/10 in value approve of the scheme. So 236 talks of purchase of minority shareholding at valuation. 237 power of the central government to provide for amalgamation in public interest. 238 registration of offer of schemes and all those things. Now, what is the process? So this compromise can be between whom the compromise or arrangement can be proposed between a company and its creditors or any class of them, between a company and its members or any class of them. Who can file the application for compromise or arrangement? An application for compromise arrangement can be filed with the tribunal by the following: company, creditors, members of the company, and in case the company is being wound up by the liquidator. Okay? Joint application. Where more than one company is involved in a scheme, such application may, at the discretion of such companies, be filed as a joint application. So, what are the conditions for serving of application in situation where application is not served by the company? Because it says even the creditors can move. So, in case the application is not served by the company, what are the conditions for serving of application? Where the application is not filed by the company, then at least 14 days before the date fixed for the hearing of the notice by the tribunal, a copy of the notice of admission and of the affidavit shall be served on the company, and where the company is being wound up on its liquidator. The applicant shall also disclose to the tribunal in the application under sub-rule 1 the basis on which each class of members or creditors has been identified for the purpose of approval of the scheme. Now, what is the format of application? Application has to be made to the tribunal for compromise or arrangement in form number NCLT 1 along with the following documents: a notice of admission in form number NCLT 2, an affidavit, copy of the scheme of compromise or arrangement, disclosure in form of affidavit including the following points: all material facts relating to the company, such as the latest financial position of the company, the latest auditor's report on the accounts of the company, and dependency of any investigation or proceedings against the company. Then, reduction of share capital of the company, if any, included in the compromise or arrangement. So, any scheme of corporate debt restructuring consented to by not less than 75% of the secured creditors in value. So, if there is any scheme of CDS, then it has to be consented by not less than 75% of the secured creditors in value, including creditors' responsibility statement. So, you can go through all these things, but let me cover the important points. Calling of meeting by the tribunal. So, upon hearing of the application, the tribunal shall, unless it thinks fit for any reason to dismiss the application, give such directions, orders as it may think necessary in respect of the meeting of the creditors or class of creditors or members of class of members, as the case may be, to be called, held, and conducted in such manner as prescribed in as follows. So, NCLT will fix the time and place of the meeting. 1 minute. So it will fix the time and place of the meeting or meetings, then appointing a chairperson and scrutinizer for the meeting or meetings to be held as the case may be, and fixing the terms of his appointment including remuneration. Then notice to be given of the meeting or meetings and the advertisement of such notice. Determining the values of the creditors or the members or the creditors or members of any class as the case may be for whose meetings is to be held. Okay. Then notice of meeting. Details of the order of the tribunal directing the calling convening, date of the order, date, time, and venue of the meeting, then details of the company, then disclosure about effect of compromise arrangement on material interests of directors, KMPs, and debenture trustees. Explanatory statement disclosing details of the scheme, summary of valuation report, disclosure about the effect of compromise and arrangement, advertisement of notice. So notice has to be in form number CA2, at least in one English newspaper and in at least one vernacular language newspaper. It shall indicate the time within which the copies of the compromise arrangement shall be made available to the concerned persons free of charge from the registered office of the company. Then notice to statutory authorities. So notice has to be given to the central government, registrar of companies, and the income tax authorities in all cases. Reserve Bank of India, SEBI, Competition Commission, and the stock exchanges. Other sectorial regulators. Okay. Representation by authorities. So authorities can also make the representation within a period of 30 days from the date of receipt of such notice. Okay. In case no representation is received, then it will be presumed that they don't have any objection. Then voting. Any objection. So persons holding not less than 10% of the shareholding, they may object. Or in case there is any outstanding debt, so persons having outstanding debt amounting to not less than 5% of the total outstanding debt as per the latest audited financial statement. Binding approval, third stage, then petition for confirming notice of hearing. This is the schedule of fees. These are the forms which are applicable. ये समरी बना दी इसकी. बस इतना ही है इसमें कॉम्प्रोमाइज और अरेंजमेंट में. ठीक है, तो मैं क्या करता हूँ, ये वाली पीपीटी भी आपके साथ शेयर कर लेता हूँ. दिस इज ए डिटेल्ड पीपीटी विच कवर्स ऑल द लॉज. ठीक है, इसमें 2193 स्लाइड्स हैं, लेकिन पूरा ये इसमें कवर करेगा ये. शेयर शेयर नहीं, यहाँ 1 मिनट, उसको ग्रुप में डालना है. मेरा क्या होता है, मैं भी बाद में निकल जाता हूँ तो वो फिर रह जाती है. अभी 1 मिनट लगेगा, अभी शेयर ही कर देता हूँ इसको. ये आ गया. अब इसमें हमने क्या किया हुआ है, इसमें केस स्टडीज भी हैं. केस स्टडीज ऑन अलाइड लॉज. अगर आप इसको पढ़ लोगे ना, फिर तो आपका कल्याण अवश्य भावी है. चलिए, दोबारा हम अपनी छोटी वाली पीपीटी पर चलते हैं. और जितनी भी वो पीपीटी है ना, सबके अलाइड आपके वीडियो लेक्चर भी मिल जाएंगे. तो एंड दैट प्लेलिस्ट आई हैव ऑलरेडी शेयर्ड इन द ग्रुप. रिमूवल ऑफ नेम ऑफ द कंपनी फ्रॉम रजिस्टर ऑफ कंपनीज. ये भी एक इंपॉर्टेंट टॉपिक है. सो सेक्शन 248 says that if the registrar has reasonable cause to believe that if the company has not commenced its business operations within 1 year of its incorporation, or if it has not been carrying on any business for the immediately preceding 2 financial years, if the subscribers have not paid the money, subscription money, and declaration has not been filed within a period of 180 days, or after physical verification, it has come to the notice of the registrar that the company is not carrying on any business, then they will issue a show cause notice to the company and all directors for removal of name, and they shall be required to file a representation within a period of 30 days from the date of notice that why their name should not be removed. So this is section 248. And if the company, they also want the name to be removed, so then they have to pass a special resolution or obtain the consent of 75% of the members after extinguishment of all liabilities. So then they have to file the application, and registrar will cause public notice that okay, nobody has any objection to the removal of the name of the company. And if company is regulated by any special act, then permission of such regulatory authority shall also be required. This is very important, that subsection 2 is not applicable to section 8 company. Sometimes they ask this question. So whether a section 8 company can apply on its own for removal of the name of the company, the answer is no. They ask this question sometimes. So you have to remember that in case of section 8, it cannot be done by the company on its own. So section 8 company cannot request the registrar for removal of the name. On the expiry of the show cause notice, suppose the registrar issued a show cause notice, then if no reply is received or no contrary is shown, then the registrar will remove the name from the register of members and it will publish in the official gazette that the company is dissolved from the date of the passing of the order. And after removal of name, if any liability is pending, then the company should ensure that there are sufficient assets or sufficient provision has been made to meet such liability. And the liability of the directors, manager, or any officer, it will continue as if the company is not resolved. So they will continue to be personally liable. Suppose some income tax liability crops up at a later date, then directors, manager, or officer will be personally liable. And nothing will affect the power of the tribunal to wind up the company, even if the name of the company is removed. Now section 249. So section 249, restrictions to make application under section 248 2. So who cannot make an application for removal of the company, removal of the name of the company? So company cannot make an application if within 3 months they have changed their name or they have shifted their registered office from one state to another. If there is a disposal of property or interest therein before discontinuation of business for disposal of gain in ordinary trading, if it has made application to the tribunal for compromise or arrangement, if the company is being wound up as per the Act or IBC. So in these situations, this application before registrar cannot be made. If there is a violation of the above provision while filing an application under section 48(2), then fine extendable up to 1 lakh rupees. Okay. And in case this fact is pointed out, then you either withdraw the application or the application shall be rejected. Section 241 talks of fraudulent application. So if any application is filed by the company under section 248(2) voluntarily with an intention to defraud or deceive any creditors or any person or to evade any liability, then there is a punishment. So punishments sections or punishment provisions are there in respective chapters also, and then 447 covers this general penalty provision. So it is punishable under section 447, and the registrar will recommend prosecution against the persons who are involved. Section 252, appeal to the tribunal. So any aggrieved person by the order of the ROC for the dissolution of the company may make an appeal to the tribunal. So they have to file the appeal within 3 years of the order, and if the tribunal feels that the removal of the name was not justified, then it will pass the order to the ROC to restore the name of the company. And before passing the order, opportunity of being heard should be given to the company, ROC and the concerned person. Registrar can also file the application within 3 years if it is found that due to mistake or on the basis of incorrect information given on consequent to that name was removed. An order passed by the tribunal is required to be filed with the ROC within 30 days, and ROC will issue fresh certificate of incorporation. Now, if the company or member or creditor or the employee feels grieved, so then they can make an application within 20 years of the order which was published in the official gazette. And if the tribunal is satisfied that the company was carrying on the business or operations, then it will order to restore the name and issue directions that the name of the company had not been struck off from the register of companies, and the name shall be reinstated. Now NCLT and NCLT. Sometimes they ask questions on this also. NCLT. So section 408, central government by notification has established the tribunals, and what are the posts in case of NCLT and NCLT. In NCLT, president is there, and then members are there, judicial members and technical members. And in case of NCLT, chairperson is there, who is the head of the NCLT, and then there are two kinds of members, judicial member and technical member. Qualifications, president or chairperson. Sometimes they ask question on this, so you must remember this thing. ये बिल्कुल बेसिक पीपीटी है, इतना तो आपको याद करना ही है, रट लेना है, इतना तो समझ लीजिए आप. So for NCLT, you have to be judge of the High Court for a period of 5 years. Okay? And in case of NCLT, you should be a Supreme Court judge or Chief Justice of High Court. Okay? For judicial member, the person should be a judge of the High Court or district judge for 5 years or advocate on record for period of 10 years. For NCLT judicial member, judge of the High Court or tribunal member for 5 years. In case of technical members, he should have 15 years of experience, CA, CS, ICWA, or 5 years as presiding officer of any labor court or tribunal. And in case of NCLT, he should be a person of proven ability, integrity, or professional experience of 25 years. Term of office. They ask questions on this also. कई बार पूछ लेता सवाल. For tribunal, 5 years. Term of office is 5 years, and reappointment can be done for next 5 years, and minimum completed age is 50 years. For president, 67 years. For members, it is 65 years. Tribunal के केस में. ठीक है. For appellate tribunal, the term of office is 5 years and reappointment can be done for next 5 years, और minimum completed age इसमें 50 years है. फॉर चेयरपर्सन 70 years मैक्सिमम है, एंड फॉर मेंबर्स 67 years. ठीक है. There is a procedure for removal of members if a member is adjudged insolvent or if he is convicted of offense involving moral turpitude, if he is physically or mentally incapable, if he has acquired financial or other interest which will hinder their function as such member, if he has abused his position. So then, in case of B to E, opportunity or reasonable opportunity of being heard will be given and he will be removed only by the order of the central government. ठीक है. But in case of A, दिस ये जो अपॉर्चुनिटी ऑफ बीइंग हर्ड वाला कॉन्सेप्ट नहीं है. ठीक है. अपील प्रोसीजर एंड जुरिस्डिक्शन. सेक्शन 421. सेक्शन 421 बोलता है कि अपील अगेंस्ट द ऑर्डर्स ऑफ द ट्रिब्यूनल कैन बी मेड टू द एपीलेट ट्रिब्यूनल. 45 डेज का इनिशियल पीरियड है प्लस अनदर 45 डेज एक्सटेंशन. ठीक है. एंड इफ एनसीएलटी और पास्ड ऑर्डर विद द कंसेंट ऑफ बोथ द पार्टीज देन देयर इज नो कॉन्सेप्ट ऑफ अपील. ठीक है. कई बार होता है ना, दोनों पार्टीज एग्री कर लेती हैं, तो फिर उस केस में अपील का प्रोविजन नहीं है. सेक्शन 423 अपील टू द सुप्रीम कोर्ट. इनिशियल पीरियड इज 60 days एंड another 60 days extension may be given. And appeal can be filed only on question of law, not on question of facts. ठीक है. सेक्शन 422. सेक्शन 422 talks of disposal in appellate tribunal or supreme court. So it has to be done within 3 months and maximum extension of 90 days. सेक्शन 424 बोलता है एनसीएलटी एंड एनसीएलटी आर नॉट बाउंड बाय द प्रोसीजर ऑफ सिविल कोड. ठीक है. सो इट शैल रेगुलेट इट्स ओन प्रोसीजर बेस्ड ऑन द प्रिंसिपल्स ऑफ नेचुरल जस्टिस. Civil court will not have jurisdiction to issue stay order or injunction order, and limitation act will also apply in case of appeals etc. ठीक है. तो ये हमारा था कंपनीज एक्ट, वेरी ब्रीफ, लेकिन इतना तो आपको याद करना ही है. और इसमें क्वेश्चन देखो ज्यादातर कहां से पूछेगा, या तो पूछेगा आपका प्रोस्पेक्टस में से. प्रोस्पेक्टस में पूछ लेता है रेड हेरिंग प्रोस्पेक्टस या शेल्फ प्रोस्पेक्टस. ठीक है. शेयर कैपिटल, रजिस्ट्रेशन ऑफ चार्ज, एनुअल रिटर्न्स में कई बार पूछ लेता है एजीएम वगैरह कितने पीरियड में होनी चाहिए, क्या है. कोरम के ऊपर कई बार सवाल पूछता है, सीएसआर रिस्पॉन्सिबिलिटी पर. रजिस्टर्ड वैल्यूज में पेनल्टी प्रोविजंस पूछ लेता है आपसे. कॉम्प्रोमाइज अरेंजमेंट में पूछ लेता है कि हाउ मच क्रेडिटर्स शुड एग्री, है ना, उसमें 90% का लिमिट है, वो उनका फेवरेट क्वेश्चन है ना. रिमूवल ऑफ नेम में सेक्शन 8 पर पूछ लेता है कि वेदर सेक्शन 8 कंपनी कैन अप्लाई फॉर रिमूवल, या री स्टेटमेंट कितने पीरियड में हो सकता है, व्हाट आर द ग्राउंड्स एटसेट्रा. और फिर इस पे एनसीएलटी और एनसीएलटी मेंबर्स पे पूछता है सवाल वो, है ना. मैक्सिमम एज लिमिट कितनी है, ये सब चीज. नाउ इंडियन पार्टनरशिप एक्ट. पार्टनरशिप एक्ट में उनके लिए दो मेन फेवरेट सब्जेक्ट है. क्या क्या? एक तो है एक्सपल्शन ऑफ पार्टनर और दूसरा है आस्किंग फॉर अकाउंट्स ऑन डिसोल्यूशन ऑफ द पार्टनरशिप. ये दो मेन मेन वो पूछता है और उस पर केस स्टडी भी बना देता है. हम्म? तो पार्टनरशिप एक्ट में देखते हैं. Two or more persons, as we know, can form partnership. If they agree to carry on the business, it should be to share profits. It should be carried on by all or any one of them acting for all. Maximum number of partners is 50 as per section 464 of the Companies Act. ठीक है. Mutual agency means one person is acting for the other. One is principal as well as the agent of the other partners plus sharing of profit. ठीक है. तो म्यूचुअल एजेंसी इज द मेन क्राइटेरिया फॉर पार्टनरशिप एंड ओनली फॉर शेयर ऑफ प्रॉफिट then it is not partnership. ठीक है. If somebody is allowed only for sharing of profit and not of losses, then it is not a partnership. Minor की केस में exception है, so minor can be admitted to the benefits of partnership. लेकिन ऐसा नहीं हो सकता कि एक आदमी एडल्ट है और एक माइनर है, तो that is not a partnership. ठीक है. दो अगर पार्टनर है, अगर पार्टनरशिप है ऑलरेडी, then only minor can be admitted. So characteristic of partnership, two or more partners. Just a minute. एक मिनट. हाँ जी. So two or more partners, then unlimited liability is there. Even their personal assets could be attached. There is a concept of voluntary registration. So it's not necessary that you should compulsorily register yourself. So it is voluntary. Okay? No separate legal existence apart from the partners. There is a restriction on transfer of interest, and partners are competent to contract, except minor, with the consent of all the partners. It can be formed only for a lawful object, and it is based on the agreement, which may be oral or written. ठीक है. कई बार पूछ सकता है ओरल पार्टनरशिप भी हो सकती है. आंसर इज यस. ऐसा कोई रिटर्न का कोई जरूरी नहीं है. Types of partnership. Partnership at will. Partnership may be for a fixed duration. Partnership may be for a particular business. Okay. Types of partners: active or ostensible partner, sleeping or dormant partner, nominal partner, partner in profit only, incoming or outgoing partner, partner by holding out or by estoppel, sub partner. So these are the various types of partners. Admission of partner. So if you want to admit a partner, consent of all the partners is required. And liability of new partner. ये लाइबिलिटी वाला पॉइंट भी बहुत इंपॉर्टेंट है कि लाइबिलिटी व्हेन इट अराइजेज एंड व्हेन इट इज नो मोर लाइबल. ठीक है. सो लाइबिलिटी ऑफ न्यू पार्टनर स्टार्ट फ्रॉम द डेट ऑफ एडमिशन अनलेस ही एग्रीज फॉर पास्ट लाइबिलिटी विद द कंसेंट ऑफ क्रेडिटर्स. ठीक है. If A and B were old partner and C was admitted with past liabilities, then also creditor cannot demand from C. ठीक है. Creditors can demand only from A and B, and in turn they can ask from C. ठीक. Now retirement of partner. Partner can retire by the consent of all the partners. It may be express, an agreement or notice to other partner if partnership is at will. ठीक है. Retiring partner is not discharged from the old liability unless the continuing partners agree. ठीक है. With the creditors and new reconstituted firm execute the contract with the creditors. Otherwise, he will be liable for the liability which was contracted when he was a partner. ठीक है. But if there is an agreement with the creditors, then he may be exempted from the old liabilities. The retiring partner is liable till public notice is given. He shall continue to be liable. ठीक है. Suppose a person deals with the firm and he was not aware that the retiring partner was there in the firm, then in such case, retiring partner is not liable. And notice can be given by the retiring partner or continuing partner. Expulsion of partner, most favored topic for case study. Expulsion provision must be mentioned in the agreement. Consent of majority of the partners is required. It should be done in good faith, not to settle personal scores. Expulsion must be in the interest of the firm. He should be given notice for expulsion. And opportunity of being heard must be given, else expulsion is null and void. Okay? And it is not dissolution of firm. So firm can continue if it is at will. We'll do a case study also on this. Insolvency of partner. He cannot continue as partner if a person is adjudged insolvent or insolvency proceedings have been instituted against him. He cannot continue as a partner, and he ceases to be a partner from the date of the order. His estate is not liable for any act done by the firm after the date of the order. Firm is also not liable for any act done by him after the date of the order. And if rest of the partners agree to continue the firm, then they can do so. Regarding death of partner, in general, firm will get dissolved on the death of any partner. But if it is provided in the agreement that the firm can continue, so then the firm shall continue even despite the death, but minimum number of partners should not go below 2. So if there are only 2 partners, one dies, then the firm is compulsorily dissolved. Okay? And in case of death, no public notice is required to be given, unlike in the case of retirement. Okay? Minor partner. So during the age on minority, he may be admitted only for profits, not for losses. Okay? He is entitled for profit and property of the firm. He has right to access to the books of the firm. He is not personally liable, but his profit and property in the firm is liable. He can file suit against the firm for profit and property, but not vice versa. मतलब firm cannot file suit, but he can file suit against the firm for profit and property. Now, after he attains majority, then what will happen? They ask questions on this. So within a period of 6 months, he has to exercise the option whether he wants to continue or not. So public notice should be given by him within 6 months, and if he fails, then he is automatically treated as continuing partner. If he accepts to continue as partner, then he will share same position as other partner. He is personally liable from the date when he was admitted to the benefits of partnership. Okay? And share of profit and property is the same as before. Okay? If he is not accepted, basically he is not willing to continue as a partner, then the liability, he will be liable. Basically, he is not personally liable, but his profit and property in the firm will be liable. Okay? He will be not liable for any further liabilities, and he will take a share of profit and property. Uh, Otherwise, he can sue the partners for recovery of such an amount.
So in this case,
Yes.
can we go back to the previous slide? In the case of minor, it's mentioned that if he accept to continue as partner,
Yes.
uh, he he, uh, he will share of profit and property in same as before, and personally liable from the date of admitted to the benefit.
Yes.
So
Yes. Yes.
from the
Yes.
date of admission of benefit means that when he was initially joined as partner, being a
Right.
minor.
Right. Right. In case he, any case he accepts to continue as partner, then he will be personally liable.
So whatever be the liability prior to the date of becoming his major, uh, that he will be liable for the previous period also when
Yes.
he
Yes. 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 He is
minor.
liable. He is liable. Dissolution of firm. Section 40 talks of voluntary dissolution, and then 41 talks of compulsory dissolution. So voluntary dissolution can be made by mutual agreement with the consent of all the partners, or as per the contract or agreement entered into between the partners. Section 41 talks of compulsory dissolution. It could be on happening of certain events, suppose death of a partner, and if the object becomes unlawful. And if the firm has more than one object, then uh, they can continue with the object which is lawful. Section 42 on happening of certain contingencies. If the firm was formed for the fixed duration, so then it will be dissolved on the expiration of that period. If it was made for a specific adventure or project, if any of the partners is adjudicated as insolvent, so then also the firm shall stand dissolved unless remaining partners want to continue. In case partnership is at will, so any partner can give notice for dissolution, and it is dissolved from the date mentioned in the notice or the date on which the communication is complete. Dissolution of firm on orders of the court. So firm can be dissolved as per the orders of the court also. So if there is insanity or unsound mind of the partner other than sleeping partner, if there is permanent incapacity, if there is misconduct, persistent breach of contract, suppose some theft is there, you are keeping erroneous accounts, then holding more cash in hand, if you refuse to show account on repeated request. So basically in this case, the registrar will take action. Okay? And the court will order dissolution of the firm. If there is a transfer of interest, if there are consistent or continuous or perpetual losses, so that the business cannot be carried on except at a loss. So these are the various grounds on which firm may be dissolved as per the orders of the court. Okay? If there is a deadlock in management, if they are not on talking terms, or if there is a loss of substratum or gambling, etc. So on all these accounts, the firm may be dissolved as per the orders of the court. In this case, normally the registrar makes the application. Registration of firm. So at any time you can register. You have formed a partnership today, you can register even 10 years after your formation. Application form is there in the prescribed fees. Application should be signed by all the partners or authorized representative. Then statement should be required to verify and signed by the all. And on satisfaction by the registrar, it will make entry in the registrar form and issue certificate of registration. Consequences of non-registration. Because it is voluntary. Registration is voluntary. So it says कि partner or firm cannot file civil suit against third party. So if you are not a registered partnership, then you cannot file a suit against the third party in civil court. Then no relief to partner for set off of claim. Okay? Maximum 100 rupees set off is allowed. And aggrieved partner cannot take legal action against other partners of the firm because your existence is not proved. So, but if you are a registered firm, then you will be able to give your certificate of registration and then you can file suit against third party, against partners, you can claim set off also. Okay? But third party can sue the firm or partner although your firm is not registered. Okay? Now limited liability partnership, LLP. LLP में फेवरेट सब्जेक्ट है उनका फॉरेन LLP. जाओ पूछते हैं फिर ऑडिट किस किस केस में कंपलसरी है. ठीक है. This Indian Partnership Act does not apply to LLP. So it's a hybrid form of partnership firm and private limited company. So LLP can do their business of trade, profession, services and occupation. Important definitions in LLP. Body corporate. So it includes company registered in India or abroad or LLP registered in India or abroad. It does not include a corporation, cooperative society, any other which is notified by the central government. Tribunal means the NCLT, appellate tribunals NCLT, financial year, period from 1st day to 31st March. ठीक है. So any LLP which is incorporated on or before 30th September, then the ensuing 31st March will be the year end. If it is incorporated after 30th September, then 31st day of March of the year next to following that year shall be the financial year. Partners could be individuals or body corporate. So this LLP can have body corporate as its partners. And there are two types of partners and designated partners. Designated partners basically they are responsible, है ना, जैसे बोर्ड ऑफ डायरेक्टर्स होता है कंपनी में, इसी तरह से यहाँ पर है designated partners. So any individual or body corporate can be partners in LLP, but following shall not be capable of becoming a partner. If is of unsound mind, which is found by the competent court, undischarged insolvent, if he has applied to be adjudicated as insolvent and application is pending. ठीक है. Minimum 2 partners are required, no maximum limit. Minimum number should not go below 2 for more than 6 months. ठीक है. Unless otherwise continuing partner shall be personally liable for the obligation of the LLP which were incurred during that period. ठीक है. Designated partner, important concept है. Minimum 2 designated partners are required. ठीक है. Both should be individual and one of them should be resident in India. ये भी important है. ठीक है. Then nominee or body corporate can act as designated partner. ठीक है. He may become designated partner by specifying in the incorporation document or LLP agreement. Consent of designated partner to act so is must. ठीक है. तो फॉर्म प्लस कॉन्सेंट प्लस प्रेस्क्राइब फीस इज रिक्वायर्ड टू बी फाइल्ड विद इन 30 days ऑफ द अपॉइंटमेंट और सेसेशन ऑफ दिस डेजिग्नेटेड पार्टनर. डी पिन है, जैसे उसमें सिन नंबर है यहाँ पर है, वहां डिन नंबर है, यहाँ पर डी पिन है. Liability of designated partner is for all the compliances and any penalty imposed on LLP, for that also he is liable. If there is any vacancy of designated partner, it has to be filled in 30 days, else all the partners shall be deemed as designated. Incorporation and other related matters. So two or more persons associated for carrying on any lawful business for profit. Incorporation document. ठीक है. इनकॉर्पोरेशन डॉक्यूमेंट में क्या क्या होगा? पी, एफ एंड बी. पी क्या है? पार्टनर्स नेम एंड एड्रेस. एफ से क्या होगा? फॉर्म. ए से क्या बनेगा? एड्रेस ऑफ रजिस्टर्ड ऑफिस. एन से बन गया नेम ऑफ द एलएलपी. डी से बन गया डेजिग्नेटेड पार्टनर डिटेल्स और बी से बन गया प्रपोज्ड बिजनेस. तो पी, एफ एंड बी ये होना चाहिए इसके अंदर. ठीक है. ये चीज जरूरी है. Statement in the prescribed form is to be made stating that the requirement of the act and rules made thereunder have been complied with for the incorporation and matters incidental to that. एक मिनट मेरे को दीजिए, मैं जरा पानी पी लूं. केबी कुमार जी आप जरा पढ़िए तब तक. So statement in the prescribed form is to be made, stating that requirement of the act and rules made thereunder have been complied with for the incorporation and matters incidental thereto. Such a statement should be made by any one of the advocate, CA, CS or cost accountant and one of the subscribers to the incorporation document. LLP agreement should be filed within 30 days of the incorporation of LLP. So mutual rights and duties of partners and rights and duties in relation to LLP are governed by LLP agreement. Okay? And if LLP agreement is silent on any matter, then schedule 1 of the act shall be followed. Okay? An agreement made before incorporation, then it can be ratified by all the partners. If the registrar is satisfied with all the above documents, then he can register and issue incorporation certificate under the official seal within 14 days. तो ये incorporation से related matter है. चलिए. शेड्यूल्स टू दी एक्ट. शेड्यूल 1 है, जैसे टेबल ए होता है कंपनीज में, तो जैसे यहाँ पर शेड्यूल 1 है. इट इज रिलेटेड टू म्यूचुअल राइट्स एंड ड्यूटीज ऑफ द पार्टनर्स एंड राइट्स एंड ड्यूटीज ऑफ द पार्टनर विद एलएलपी. So this schedule is applicable in absence of agreement on the matters. Schedule 2 क्या है? Related to conversion of partnership firm into LLP. ठीक है. Schedule 3 है related to conversion of private limited company into LLP. और Schedule 4 है related to conversion of unlisted public company into LLP. Now cessation of partnership interest. A person who ceases to be a partner as per the provisions mentioned in the agreement or in the absence of such provision, not less than 30 days notice is to be given to other partners of his intention of ceasing to be a partner. ठीक है. It can be done by the following: on his death or dissolution of the firm, if he is declared unsound mind by the competent court, or if he is applied to be adjudged as insolvent. ठीक है. So partner ceases to become so, but he is still liable unless third party is aware of his cessation or notice is delivered to the registrar. He is liable for the old liabilities during his tenure as partner. He is entitled for the contribution made in the LLP and share of profit after reduction of accumulated losses, if any. Okay? And after cessation, he cannot interfere in the management. Then registration of charge. Registration of change of partner or their details. So if name or address is changed, then it is his duty to inform the LLP within a period of 15 days. And LLP should inform the registrar within 30 days of admission or cessation of partner or the change in information of partner of about such change. ठीक है. पार्टनर इन्फॉर्म करेगा एलएलपी को और एलएलपी इन्फॉर्म करेगी रजिस्ट्रार को. ठीक है. Whosoever contravenes, he shall be liable for penal provisions. Partner can also file directly of his cessation, and registrar will first try to take confirmation for LLP firm, and if no confirmation is received, then within 15 days, ROC will register the change. ठीक है. Section 26 बोलता है all partners are agent of LLP firm only, not of the other partners. ठीक है. जैसे पार्टनरशिप में क्या होता है, एवरी पार्टनर इज ए प्रिंसिपल एंड एजेंट, है ना. पर यहां पर क्या है, पार्टनर्स आर एजेंट ऑफ एलएलपी. ठीक है. लेकिन दे आर नॉट एजेंट्स ऑफ अदर पार्टनर्स. Extent of liability of LLP partners holding out. So any partner, if he acts without the authority, he will be personally liable. ठीक है. LLP or other partners are not liable. If any wrongful act is done or there is any omission by any partner in the ordinary course of business, then LLP is liable. Any act of wrongful or omission by any partner, then other partner is not liable. Any obligation of LLP arises as per the contract, then LLP is liable. Liability of LLP shall be met out of the property of the LLP. ठीक है. Personal liability नहीं है. In case of holding out, the person is liable, and if any credit is availed by LLP, then to that extent LLP is also liable. By LLP poses before others that he is our partner. ठीक है ना. Then LLP is also liable. After the death of partner, if his name is used, then deceased partner is not liable for that. If business is carried out to defraud the creditors or any person or for fraudulent purpose, then LLP and partner who acted is liable for unlimited liability. ठीक है. And if LLP proves that it was without the knowledge or authority of LLP, then LLP is not liable. If LLP, partner or designated partner or employee conducted this affairs in a fraudulent manner, then they are liable to compensate the person who suffered and without prejudice of any criminal proceedings. Here also, LLP proves that it was done without the knowledge of LLP, then it can be saved. Okay, from any liability. Maintenance of accounts, audit and filing. कब ऐसा सवाल पूछ लेता है. So LLP is required to maintain accounts. You can maintain accounts either on cash or accrual basis, on double entry system, maintained at the register office. Okay, for the prescribed period, 8 years. Audit is required if turnover is 40 lakhs or more, or contribution is 25 lakhs or more. Statement account and solvency shall be prepared within 6 months from the end of the year, and it has to be filed within 30 days in form number 8 along with prescribed fees. Annual return should be filed within 60 days of the end of the financial year in form number 11 plus prescribed fees. If there is a violation, then LLP and all designated partners are liable. Okay. Section 69 permits for late filing within 300 days of last date of filing with additional fees of 100 rupees per day of delay. And after expiry of 300 days, you can file it with additional fees without prejudice to any other action or liability. Winding up. It can be done voluntarily or as per the directions of the tribunal. Under following circumstances, LLP shall be wound up by the tribunal. When the LLP so decides, when number of partners falls below 2, okay, for more than 6 months, if it is unable to pay its debts, if the LLP is affecting the integrity of India, interest of sovereignty or security of state or public order, if there is a default in filing of statement of account or annual return for consecutive 5 years. ठीक है, कंपनी में 2 years है, यहाँ 5 years है. Or if the tribunal feels that it is just and equitable to wound up the LLP. Indian Contract Act. कॉन्ट्रैक्ट एक्ट बाद में कर लेंगे, पहले कुछ और देख लेते हैं इंपॉर्टेंट. कॉन्ट्रैक्ट एक्ट तो आप कर ही लोगे. क्वांटम मेरिट के ऊपर कोई बार क्वेश्चन पूछ लेता है. क्वांटम मेरिट क्या होता है? क्वांटम मेरिट मीन्स लिटरली एज मच एज इज अर्नड और अकॉर्डिंग टू द क्वांटिटी ऑफ वर्क डन. ठीक है. When a person has begun the work and before he could complete it, the other party terminates the contract or does something which makes it impossible for the other party to complete the contract, he can claim for the work done under the contract. He may also recover the value of the work done. क्वांटम मेरिट के बाद सवाल पूछ लेता है. क्वांटम मेरिट का मतलब है एज मच एज इज अर्नड और अकॉर्डिंग टू द क्वालिटी ऑफ वर्क डन. इंडेमनिटी और गारंटी में फर्क क्या है? Contract of indemnity. What is the contract of indemnity? So there is a promise to save from the loss. So loss may be caused by the conduct of the promisor or conduct of any other person. Indemnifier कौन है? Indemnifier is the one who promises to make good the loss, and indemnified is the person whose loss is to be made good. ठीक है. फिर कॉन्ट्रैक्ट ऑफ गारंटी. इंडेमनिटी अलग है, गारंटी अलग है. गारंटी के केस में क्या है? देयर आर 3 पार्टीज, है ना. गारंटी वाला कॉन्सेप्ट तो आईबीसी में भी है. गारंटी में क्या होता है? देयर आर 3 पार्टीज. वन इज द प्रिंसिपल लेटर, उस जिसका प्राइमरी ऑब्लिगेशन है, देन क्रेडिटर एंड देन श्योरिटी. ठीक है. लाइबिलिटीज किसकी है? प्राइमरी लाइबिलिटी प्रिंसिपल डेटर की है, सेकेंडरी या कोलेटरल लाइबिलिटी आपका श्योरिटी का. एंड देयर आर 3 कॉन्ट्रैक्ट्स इन केस ऑफ कॉन्ट्रैक्ट ऑफ गारंटी. वन इज बिटवीन द प्रिंसिपल डेटर एंड द क्रेडिटर. Second is between the surety and the creditor, whereby the surety agrees to pay for the debt of the principal debtor. And then another contract between the principal debtor and the surety, where the surety steps into the shoes of the creditor. ठीक है. एक बार surety ने पेमेंट कर दिया creditor को, he can recover it from the principal debtor. There is a concept of discharge of surety. Discharge कब हो जाता है surety? When there is a variation in terms of the contract without his knowledge. ठीक है. Or if there is a release of the principal debtor, then the surety is also discharged. There may be released by contract also, released by act or omission of the creditor. But there is no discharge if the surety assents or release of one surety does not result in discharge of the co-surety. Bailment and pledge. Bailment and pledge पे sometimes they frame a case study. You give your coat for stitching, it's a contract of bailment. You give your watch for repair, it's a contract of bailment. And then there are duties of the bailer and bailee. A delivery of goods by one person to another, for some purpose upon a contract, that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them is called as bailment. क्रिएशन ऑफ एजेंसी, एजेंसी पर कई बार सवाल पूछ लेता है. तो creation of agency could be by express agreement, it could be by implied agreement. Implied agreement में क्या होगा? It is by estoppel, it may be by holding out or it may be by necessity. ठीक है. And then agency could be created by ratification also or by operation of law. ठीक है. ये केस स्टडी है तो आप देख सकते हैं आराम से, कोई दिक्कत नहीं है. डू दिस स्टडी. एक मिनट में जरा इससे आगे चलता हूँ. ये सब आपको रिकॉर्डिंग में भी मिल जाएगा. वी हैव डिस्कस्ड ऑल दिस थिंग्स. करते हैं अभी थोड़ा सा, इसको थोड़ा डिस्कस कर लेते हैं. Aligned. हम्म. एक मिनट मुझे दीजिए जरा. ये फॉरेन एलएलपी इसमें आ जाता है अगर. ये तो हो ही गया. ये कर ली. ये तो कर ही लिया था हमने. और देखते हैं नीचे जाके. ये 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 तो देख लीजिएगा खास तौर से. ये केस स्टडी बना रखी है ऑन प्रोस्पेक्टस एंड अलॉटमेंट, है ना. केस स्टडी ऑन शेयर कैपिटल एंड डिबेंचर्स. मैंने हर एक टॉपिक पे एक कोशिश किया है कि थ्रू केस स्टडी आई शुड एक्सप्लेन. केस स्टडी ऑन एक्सेप्टेंस ऑफ डिपॉजिट्स, केस स्टडी ऑन अकाउंट्स, ये सारे क्वेश्चन भी हैं और आंसर भी दे रखे हैं. केस स्टडी ऑन रजिस्टर्ड वैल्यूअर्स, केस स्टडी ऑन रिमूवल ऑफ नेम, केस स्टडी ऑन वाइंडिंग अप, सीएसआर, एजीएम. हम्म. बोनस शेयर्स, रेडिंग प्रोस्पेक्टस. केस स्टडीज ये तो हो ही गया, ये कर ही लिया था हमने। ये सब आप देखोगे ना, आपको सब समझ में आ जाएगा, और हर एक की रिकॉर्डिंग भी है ऑलरेडी। LLP केस लो, केस स्टडी ऑन रेरा एंड CIRP, केस स्टडी ऑन प्रिवेंशन ऑफ करप्शन एक्ट। तो मैं तो ये चाहूंगा कि यू गो थ्रू दिस मटेरियल, और इस मटेरियल में बहुत क्लैरिटी आ जाएगी आपको। केस स्टडी ऑन एडमिशन ऑफ पार्टनर, केस स्टडी ऑन माइनर एज ए पार्टनर, केस स्टडी ऑन माइनर हो गया, एक्सपल्शन ऑफ ए पार्टनर, केस स्टडी ऑन रिटायरमेंट, केस स्टडी ऑन बेलमेंट। ये कर लेते हैं, ये बेलमेंट पे भी सवाल पूछ लेता है कई बार। ये केस स्टडी देखते हैं, इंटरेस्टिंग। ये सारी केस स्टडी मैंने खुद ही बना रखी है ज्यादातर। ये कहीं मिलेंगी नहीं बाजार में आपको। एक बार पढ़ना केवी कुमार जी, 5 मिनट लगा देते हैं इस पे, बड़ी इंटरेस्टिंग है मतलब। और एनीवन, मनु गुप्ता जी का कोई भी पढ़ लो, एनीवन।
Shyam Prasad and Chiranjilal are friends. Both are doing the business of imported foreign-made cars. In the year 2020, Shyam Prasad ordered 22 foreign-made cars to a foreign company engaged in the business of making foreign cars. Out of the 22 cars, 14 cars were delivered to Shyam Prasad in the month of September 2021, and the foreign company promised to deliver the rest of the cars latest by December 2021. The payment for all the foreign-made cars has already been made in the advance. One day, Chiranjilal came to meet with Shyam Prasad, and Shyam Prasad showed him his newly purchased foreign-made cars. Chiranjilal was very much impressed to see all those imported foreign-made cars, and he wished to make a test drive of one of those cars. Shyam Prasad made no objections to that, and Chiranjilal made a successful test drive of one of the new imported car. After successful test drive of the car, Chiranjilal offers Shyam Prasad that he wants to display those foreign made cars at his showroom situated at Greater Noida in order to increase its sales. Shyam Prasad agreed to that proposal as Shyam Prasad and Chiranjilal both were old school friends. One day, a fire broke out in the showroom of Chiranjilal and nearly 20 cars were completely destroyed due to the cause of fire, out of which 10 cars were that which belonged to Shyam Prasad. Shyam Prasad came to know about the incident and he demanded compensation from Chiranjilal for the goods handed over to the Chiranjilal. The market price of the car destroyed on the date of fire is rupees 95 lakhs, as against a purchase price of rupees 82 lakhs. In the books of Shyam Prasad, Chiranjilal spent a sum of rupees 1 lakh on the goods received from the Shyam Prasad. The rent of the showroom where goods were displayed to customers is rupees 5 lakhs per month. The period during which goods were under the custody of Chiranjilal is 2 months. The insurance company rejected the claim made by Chiranjilal, stating that the insurance was that only for the goods belonging to Chiranjilal and denied any compensation for the goods destroyed which belongs to Shyam Prasad. Now answer the following question. Is the arrangement between Shyam Prasad and Chiranjilal regarding imported foreign cars is a contract of bailment? State reasons in support of your answer.
But these are two school friends. One is displaying foreign cars in his showroom. His friend comes and he says that I also want to display in my showroom. So give me some of the cars. So this is a contract of bailment. Bailment, the bailment may be without consideration, bailment may be with consideration. It's not that this person was charging something from his friend. No. उसने बोला भाई ठीक है, जितने बिक जाएगा उसके बाद में प्रॉफिट शेयर कर लेंगे, वट एवर वी आर डूइंग। सो दिस इज ए कॉन्ट्रैक्ट ऑफ बेलमेंट। And there are certain rights and duties of bailor. So what are the rights and duties of bailor? So bailor is the person who gives his goods or property to another person, maybe for a consideration. Suppose you buy cloth from the market and you give it to tailor. Okay? So whether the tailor can keep the suit unless you pay the price, the answer is yes. So there are certain rights of the bailor, there are certain duties of the bailor. So the bailor has the right to get his goods back. You give your cow to your neighbor. You are going outstation, say for you are going to Kumbh Mela for a week. Okay. Now you hand over your cow to the neighbor, and the cow gives birth to a calf. So you are entitled for both the cow as well as the calf. So right to get his goods back, right to get the increase or profit from the goods built, right to get compensation if there is any loss. So then you have got a right to get compensation also. Okay? And you have the right to terminate the contract. So these are the rights of the bailor. Now what is the duty of the bailor? So he has to take care of the goods. It is the duty of the bailor to disclose faults in the goods bailed. It is the paramount duty of the bailor to express the fault of the goods to the bailee. And it is the duty of the bailor to give compensation to the bailee in case some harm is caused to the bailee. And then it is his duty to give the expenses. Suppose you hand over your cow to your neighbor when you are going to Kumbh Mela. Now, your neighbor has spent some money for the fodder he purchased. So, it is your duty to give him expenses and he can charge for those expenses. Similarly, there are certain rights and duties of the bailee also. So the bailee has the right to get compensation. Suppose you give your car to your neighbor, you saying I am going to a foreign country for 1 month and you take care of my car. Okay? You can drive the car also off and on, but you know that the brakes are not functioning properly. So you should have told your neighbor that the brakes are not functioning properly. Either you get them repaired and or you need not drive the car. So it is your duty. And if your neighbor is hurt because of non-application of brakes, not non-functioning of brakes, then he is liable for compensation. He is entitled for compensation. So right of bailee, right to get compensation, right to terminate the contract of bailment if the terms and conditions are decided, duties of bailee, duty to take care of goods, duty to return the goods, to make proper use of goods, duty not to mix his own goods, duty not to question the title, duty of the bailee to pay increase or profit, etc. etc. ठीक है, टर्मिनेशन केस स्टडी ऑन बेलमेंट, ये भी एक बहुत बढ़िया केस स्टडी है, तो ये भी आप देख सकते हो, ये फिर कॉन्ट्रैक्ट एक्ट पर है। तो अभी मैं चाहूंगा कि आप थोड़ा सा इसको पढ़ लें, जितनी भी केस स्टडी है, दिस मटेरियल आई हैव ऑलरेडी शेयर्ड एंड देन विल डिस्कस। ठीक है, इन केस यू हैव एनी क्वेश्चन और इफ यू हैव एनी सजेशन ऑन एनी केस स्टडी, वो भी आप मुझे दे सकते हैं। यू कैन राइट इन द ग्रुप, यू कैन राइट टू मी पर्सनली ऑल्सो। बहुत सारी केस स्टडी बना रखी है, कोई टॉपिक ऐसा नहीं जिसपे हमने केस स्टडी नहीं बना रखी। तो पूरे का पूरा इसमें डिस्कस किया गया है। अब आपकी चॉइस है, आप छोटी वाली केस स्टडी से पढ़ना चाहते हो उसमें से पढ़ लो, बड़ी वाली में से पढ़ना चाहते हो बड़ी में से पढ़ लो, दोनों चीजें अवेलेबल है। मिनिमम देखो छोटे वाले तो पढ़ना ही है, अगर आपके पास टाइम है और आपका इंटरेस्ट है तो आप पूरा कंप्लीट पढ़ो। ठीक है ना जी, ओके जी, हैव अ गुड डे।
थैंक यू सर।
थैंक यू सर।
Thank you,
जैसे
sir.
अभी 24th को एग्जाम देना है
है
तो
24th को, ठीक है।
हाँ
तो
तो
मुझसे जो चाहिए मुझे बताओ, मैं आई एम ऑलवेज